Hello, everyone, and welcome back to Coffee with Craig, where we talk about all things firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can know where the conversation is taking place. Also, if you're watching us on Facebook and YouTube, make sure you hit that notification button. Help us beat the algorithms, because they don't want you to know that we're actually on. So if you click that notification button and on YouTube and on Facebook, it'll notify you as soon as we go live, and you can participate in the live chat as the program is taking place. All right, getting into today's topic, we all know that anti-gunners go out of their way to try and restrict our ability to be able to own or possess firearms, up to and including trying to restrict it in our own homes or our places of business. Well, there's a case that we're going to talk about today where they're doing just that. Now, this case that we're talking about right here, it is Miller v. Smith. And in this particular case, they're going after both foster parents and home-based daycare operators. And they're trying to make it so that they can't own or possess firearms. Once again, in their places of business and basically where they live. And to discuss that, we have with us the Director of Constitutional Studies and Second Amendment scholar, Mr. Joseph Greenlee. Joseph, how are we doing today?
I'm doing well. Thank you for having me.
Sir, it is always a pleasure to have someone who is as knowledgeable in the history of firearms and firearms law and policy as you are.
Well, thank you. It's an honor to be here.
All right, so do me a favor. Give me a little bit of a background on this particular case.
Sure. So the Millers are the plaintiffs in this case, and they're a married couple who live in Illinois, and they are licensed foster care providers, and then they also run a daycare out of their home. And Illinois has these restrictions that effectively prohibit them from having functional firearms in the home. So for daycares, handguns are not allowed in the home, and long guns must be disassembled, locked in a safe, and then the ammunition for it must be locked in a different safe. And then you have to hang up a sign, a gun-free zone sign, so that people know that you are unable to defend the kids on your premises. And then the foster home rule requires that any firearms be locked in a safe separately from ammunition, and the ammunition must be locked in a separate safe. So it effectively takes away the right and ability to defend your home if you're either a daycare provider, home-based daycare provider, or a foster parent.
Okay, so for those who are watching the program who really don't understand why this is a problem, maybe do me a quick favor. I get it, but maybe you can explain to them, explain to them why this is such a serious problem.
Well, first of all, it applies in the home where, in District of Columbia versus Heller, the Supreme Court expressly stated that the interest of the right of law-abiding citizens to use arms in defense of hearth and home is elevated above all other interests that the government may have in regulating the right. So no matter how important, let's say, for the sake of argument, that it is in the government's interest to forbid guns in these homes, it doesn't matter. Under the Second Amendment, their interest is the right of these foster parents or home daycare providers to be able to defend their home and the people in it is paramount. So, but also it deters. I mean, it goes well beyond actually just leaving these people defenseless in their own homes, but it deters people from becoming foster parents or providing daycare, and these are badly needed services across the country. And it in many ways, not to overstate it, but it's essentially the state putting their disdain for gun owners and guns above the very real needs of these kids to have a safe home and place to in their community to live while they're going through some hard times.
Right, and what's interesting about it is the whole purpose of owning or possessing a firearm, once again, is to have it functional and prepared in the event that you need to use it to defend yourself. And the goal of the law is to render the firearm useless should you need it to defend yourself.
Yes. and sorry to jump in, but also these daycare providers, they are going out and leaving their handguns in their car in the street while they operate the daycare, and then at the end of the day the kids go home and they bring it in. So I don't see how it could possibly be more. I'm not saying the Millers are doing this specifically, but it's in the record, and there's it's noted across the country that people are doing this to not circumvent the rules, but just to comply with it. But it's hard to say that instead of it being in their home where they are comfortable with having it and being able to access it and have full control over it, that it's somehow better for public safety to require these people to store it in their car all day in the street and then retrieve it at the end of the day.
Well, now my understanding is that, stealing firearms from vehicles is probably one of the number one sources of places where firearms are in fact stolen from. So that makes absolutely no sense to take it out of the home, where it's probably either in a lockbox or a safe, and putting it in a car where and once again, it increases the likelihood or the ability of an individual to be able to steal that firearm. But I also think you make another great point. These are people who, once again, if you are a person who is a gun owner, or in particular a person who takes the time to learn and to train, you're someone who believes in the fundamental right of self-defense, and you're, by the way, the responsibility to be your own first responder. And what's crazy is they want to make sure that these values are not passed on either to foster children or to daycare children.
Yes, well, that's correct too. And then it also puts these kids in a vulnerable position, leaving them defenseless all day. And even if the parents' desire for their kids, a lot of us want our kids being in a place defended by firearms. So we want our schools secured, we want wherever our homes secured, and they don't even leave that option in Illinois. If you want your kid in daycare, it has to be in a gun-free zone, which seems problematic. I don't see how it's in the state's interest to do that and to take that decision out of the parents' hands.
Well, now under the new guidelines in terms of how a lot of these cases are supposed to be decided, is there any sort of a history or historical background that supports their position for this law, or by the way, that supports our position on this law?
Well, so Bruin, we filed a brief in this case, and as you noted, and it was before the Bruin decision came out, but Bruin strongly supports our brief, so it worked out very nicely. And of course, we anticipated that, but Bruin says it's the government's burden. It repeatedly states this like 5 times, I think, throughout the opinion. It's the government's burden to prove that any firearm regulation is consistent with the original understanding, the understanding in 1791 of the Second Amendment. And so the government here has provided no historical justification, and there is none. So we came in, the district court in this case said, oh, this is a sensitive place restriction because there are kids present. And so you can ban guns in sensitive places. And among other things, we came in and filed a brief with the Seventh Circuit. The case is now before the Seventh Circuit Court of Appeals. And we filed a brief, first of all, explaining why they misinterpreted Heller's sensitive place language, but then also providing the history. And there's no private home, whether you're looking at the founding era. Some people think you can go up to 1868 when the 14th Amendment was ratified and consider regulations up to that point. And in Bruin, there may even be disagreement among the justices, Supreme Court justices, on that issue because they sidestepped it. But either way, no matter which one you look at here, there's no historical justification. Up until around the founding era, the only restrictions ever in colonial founding era America were in polling places, legislative assemblies, and a few courts. Although about just as often you were required to carry guns to court. So that one's iffy. And then if you looked at 1868, there were a few universities, but almost all, like 5 maybe, and 3 of them were private universities. So there were 2 public institutions that forbade people from carrying guns, but no private home like the Miller's home in this case, no private home had ever been considered a sensitive place. And all the sensitive place laws, these were laws on carrying firearms, not possessing them, in your home. So I think that sensitive place holding from the district court is not only wrong, but very dangerous, because if you carry out that same rationale that if you have kids in your home, then that could be a sensitive place that the government can ban guns. And what about people with, a lot of kids? Say you have 6, 7, 8 more kids, or maybe you're that neighborhood home where all the kids play at every day, throughout the summer. you have kids around all day. It's not actually a daycare, but kids are there constantly, or maybe your grandparents and your grandkids come every Sunday and they all come at once, and you have a lot of kids in the home. So it's a very dangerous rationale beyond being ahistorical and resulting in the disarmament of a lot of lawful, peaceable, good people who just want to defend themselves and the people in their home.
Well, yeah, I think in the long run they believe. I guess they believe because they are sensitive and they have very sensitive sensibilities. That any place where they might possibly be or think about being are sensitive places, and that's not what they meant by sensitive places. In fact, from what I understand, the court ruling basically said no, you can't declare every place to be a sensitive place, which appears to be what they're trying to do.
Yes, that's correct, and that's what Bruin said, and so they clarified it. And even Heller, we focused on this in our brief too. Heller said that some laws forbidding the carrying of firearms in sensitive places such as schools and government buildings are presumptively lawful, but that there still must be a historical justification for it. So we explained there is no historical justification for this, and then also we focused on the carrying aspect of what Heller said. It didn't say anything about possessing or keeping arms, and then also. In public, it provided, government buildings and schools, and this is a private home. It's not a school or a government building or some other public location. And in Bruin, it expanded. It said polling places, maybe legislative houses, I believe, but nothing that would apply in this situation. So I'm very hopeful that the Seventh Circuit will take a closer look at this, focus on the government's complete lack of history that it provided to justify its regulation, and look at our history in which we explain that it cannot possibly justify the regulation, and then reverse the district court.
All right. Any idea when we can expect to hear something from this here on this ruling?
Just today the court granted a motion by the government for an extension of time to respond to the Miller's opening brief, and so I suspect it'll be quite a while. After that, the Millers will have a chance to file a reply, and then the court has maybe will consider oral argument, and then has who knows, it could be a few months or even over a year to issue a ruling. So okay. I don't have a very good guess.
Okay. That kind of seems to be the way the courts seem to go on Second Amendment issues. They tend to take a long time, and I think that's one of the reasons why anti-gunners feel so comfortable passing these laws, even in many cases when they know it won't pass constitutional muster, because they just know going through this process is going to take a long time, and they'll have the law in place at least for a period of time. What I find interesting is once it's been in place for a while, they actually try to use that as an argument as to why they need to keep it.
Yeah, that's right. That's right. And also don't forget, it's very expensive. So for these litigants, and that's why, if I can put in a plug, it's important for people to continue to support us, because it costs a lot of money to these cases. Not only can they take, up to a decade or perhaps even longer, but they take several years, and they can cost tens of thousands, hundreds of thousands, sometimes millions of dollars before it's all said and done. So it's a very burdensome process, and I do believe that they realize that when they pass some of these laws.
Hey, where can folks go to find out about, not just read about the cases that we file, but also where can they go and read some of the friend of the court briefs or amicus briefs that you write?
Yes, those at fpclaw.org. We'll have a list of all of the cases, like you say, the cases that we are actually the parties of, and then the briefs that we file. And these briefs allow us to just jump from case to case and be active in every case, essentially. I mean, every case that we are aware of and can be active in across the country, we'll get in there. And as long as we can provide the court with some information it doesn't already have before it, we'll get active and try to defend the rights across the country. So yeah, I'd encourage you, please check out some of our work. We think it's very important and that it's making a difference.
Excellent, sir. Thank you so very much for coming on the program. Thank you for all the work that you and the rest of the folks over there at FPC Law do. We look forward to having you back on the program soon.
Thank you. Thanks for having me.
All right. All right, so folks, just so that you know, the Firearms Policy Coalition is a membership organization. What does that mean? That means that we need your support. We need you to become members of the Firearms Policy Coalition. To do the work that Joseph and the rest of the folks over there at FPC Law do, we need your support. We need you to become members today. All you got to do is follow the join link in the description to this video, and, well, you can become a member. It's really that simple. I always like to say, either you're part of the solution or you're part of the problem. Don't be part of the problem. Become a member of FPC today. And if you are a member, or if you're just looking for another way to support, you can always go to FPC Gear. That's right, FPC Gear. It is the place to go to get all of your Pro 2A swag. We have t-shirts with all sorts of cool sayings and whatnot on them. We have hoodies, we have tank tops, we have all sorts of fun stuff. And the best part about FPC Gear is that every dollar that you spend goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, that's going to be it for today's program. We very much appreciate you tuning in. We appreciate you liking and sharing the program and encouraging your friends to do the same. Remember, this is a fight for our civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.